Good afternoon, everyone. It gives me great pleasure to welcome you all to today's talk. We're delighted to have with us Professor Hoi Kong, who's an associate professor at the McGill University Faculty of Law. There, he teaches administrative law, municipal law, constitutional law, and comparative law. Hoi has done an extensive amount of work in the field of community engagement, deliberative democratic practices, and he is currently directing a research program on deliberative governance. He's here attending another conference where he'll be speaking on Wednesday in relation to planning, and we're very, very delighted that he's able to spend some time with us to share his current work. Please join me in welcoming Hoi. Thank you.
So thank you all so much for being here. It's such a pleasure to always come back to Hong Kong, and thank you to Pooja and the Center for hosting. I know that it's a busy term and everyone is taking time out of their day, so I'm really grateful for your time. So Pooja and I were talking about this talk over lunch, and the topic, this idea, this connection between the rule of law, democracy, and actually the idea of law itself, and its connection to the rule of law and to democracy. These are long-standing debates, and they are the kind of debates that you have going from generation to generation, sitting in faculty seminar rooms, and people have come up with sort of refined arguments. And some of the debates tend to have a kind of how many angels are dancing on the head of a pin kind of feel to them. They're very sort of academic, very university and eternally focused. But it turns out that actually these debates are, with current events around the world, real world debates. These are debates that have actual stakes in the real world. And so I thought I would start with real world applications. And so some of the conceptual arguments or academic arguments that are made within the academy, I think, have real world impacts. So I thought I'd start by offering two examples of statements that either have been made or could be made about law, governance, and I suggest that these statements represent errors in understanding the relationship between the rule of law and democracy. But let's just start with the statements. So one statement goes something like this. The leader has been elected by the people. He enjoys the will of the majority. Right? What that leader does is by definition lawful, because he's received the assent of the will of the people. Yeah? And what he says and what he does will not be questioned. I was going to name this character Mr. Orange. There's a second kind of argument that is sometimes made, a second version of arguments about law and power and politics. And this argument goes something like this. The statement goes something like this. The rule of law is merely an instrumental value. Yeah? The rule of law and laws are mere instruments, and they are fully compatible with a whole range of different kinds of policy objectives and different political theories. Yeah? And to assert otherwise, to make the kind of claim that I am making today about the connection between the rule of law and democracy, is to engage in a kind of act of intellectual, at its best, it's kind of like intellectual missionary activity, coming in, preaching to you about the relationship between the rule of law and democracy. And at its worst, it's a kind of Western imperialism, an imposition of a contingent conception of the rule of law, right, and its normative value. And the claim that there's an intimate connection between the rule of law and democracy is an act of imperialism that ignores the vast diversity of ways in which law and the rule of law should be understood. Okay? So two statements about the nature of law. One says, the leader who receives the will of the people acts by definition in a lawful way and will not be questioned. The second says, any claim about the rule of law and democracy is a kind of imperialistic claim, right? And ignores the fact that the rule of law is merely an instrument. It's an instrument of governance, does not have an intimate connection with democracy. Two claims. And so what I hope to show over the course of the presentation today is that both of these statements are errors. Yeah? They're errors in the kind of way that errors are important in academia. That is, the errors, I think, they're conceptually muddled, and I think they're wrong for that reason. Right? But there are also errors, I think, in when they are applied in the real world, because when these ideas are put into practice, they have profound effects on people's lives. Okay. So the presentation today will progress in two parts. First, I will set out some definitional questions. So one of the benefits of talking about things like the rule of law and democracy is that everyone has a specific definition. I will argue for a specific definition of each of these terms: the rule of law, democracy, and law. Second, I will then look at the statements that we've just canvassed, Mr. Orange and Mr. Turquoise. Right? Mr. Orange and Mr. Turquoise. And I'll highlight the ways in which those are errors, given the definitions that I have set out. Right? And I'll close with some thoughts about how to respond to what I think is the most important insight of Mr. Turquoise's argument. Okay, so let's start with the rule of law. So as I say, this is a conversation that is long-standing. There have been debates about the nature of the rule of law forever. Yeah? And essentially, in the contemporary literature, there's a kind of debate between what are called thick and thin versions of the rule of law, as some of you know. Yeah? So thin versions tend to focus on procedural conceptions of the rule of law. Thick conceptions tend to focus on substantive ideas of the rule of law. Now, the rule of law is not merely a matter of procedures, but it also requires certain commitment to some substantive values. Yeah? So I thought what I would do is I would start with the thin conception, which I think everyone more or less agrees is a true picture of what the rule of law is, and I think the debate is about how much more is there to the rule of law beyond the thin version of the rule of law. So I thought we'd start with a standard list of the kinds of things that people think of as necessary for the rule of law. And the list I'm going to pull out is from Lon Fuller's great book, The Morality of Law. And there's a list he gives of 8 elements, right? 8 desiderata, 8 call them criteria, right? For deciding whether or not a system of rules is a system of laws. Yeah? So let's go through them. So one is that in order to have a system of laws, you have to have rules, right? You cannot simply have a system of one-off commands from the ruler. Yeah? So one element of the rule of law, one of the desiderata, one of the criteria for the rule of law, is the existence of rules, not simple governance by commands. Second, rules must be prospective. Yeah? That is, they're forward-looking. You can't typically enact a rule and then punish somebody for having failed to comply with the rule because they didn't comply with the rule yesterday. Yeah? Rules in general are prospective; they're forward-looking. Yeah? For the students of the room, I know that grading doesn't feel like that, but in principle, that's how rules should work. Yeah? So there must be rules, not merely commands. Rules must be prospective. They must be general. Yeah, that is, so in a legal system, the idea is that rules in a well-functioning system of rules that complies with the rule of law, rules must be of general application, right? So I cannot enact penal provisions that directly target puja. In part because I also in addition do not have any actual power, right? But rules must be general. They must be rules, general, prospective. They have to be non-contradictory. Yeah? So puja can't be punished for both being puja and not being puja. Yeah? That is, the rules must they must be non-contradictory. They must be possible to comply with. Right? So you cannot enact rules and impose penalties for things that people cannot do. Yeah? So in my case, I could not be punished for not being able to slam dunk a basketball. Yeah? You cannot have a system of rules that punishes me for not being able to slam dunk. Yeah? So rules must be possible. They must be possible to comply with. Rules must be public, right? In a system of the rule of law, You cannot have rules which are secretive, right? So people are not punished for non-compliance with rules that they can't possibly know about. Right? Rules must be not constantly changing. Yeah? So if in a system governed by the rule of laws, the rules in the law books can't be changing every 48 hours. Yeah? They're not like your Facebook updates. And there finally must be a congruence between the acts of legal officials and laws, right? So legal officials, when they act in ways that are consistent with what the laws require. Yeah? So 8 elements of the rule of law. There must be rules. It must be prospective, general, non-contradictory. It must be possible to comply with them. It must be public. And they can't constantly be changing. And there must be a congruence between what the officials do and what the rule of law and what the laws require. 8 elements of the rule of law. Now, the question is, one interesting question is, well, what is it that these 8 indicia do? Right? Is it simply a checklist? Do we just go down the checklist and say, well, if you have these 8 things, then you have the rule of law. Right? Or if you're missing some of these things, you don't have the rule of law. Now, Fuller himself said that you do not have a system of law when you have a catastrophic failure of these indicia, right? So imagine that you are in a legal system in which all laws are secretive, right? Citizens are governed purely by laws that they have no idea of their content or even of their existence, yeah? In that kind of a world, I think we would be able to say, I think most people in the room would agree, we are no longer governed by a system of laws, right? If laws are simply a matter of specific rules that target individuals, yeah? And that's all they are, then we no longer have a system of law rules that is worthy of the appellation of law. There's a drastic non-compliance with the rule of law. Okay, so that's one of the things that, one of the purposes of the indicia, right, is to say that if there is a catastrophic failure to comply with these elements of the rule of law, then we do not have a system of rules that is worthy of the name law. Okay. Now, what's the underlying moral purpose of these 8 indicia? Yeah, that is, they're not simply checklists. They actually serve some kind of moral purpose. I want to suggest a couple of them, right? One of which is that it sets a kind of relationship between those who govern and those who are governed, between the rulers and the citizens. Yeah? So if you have rules that are public, that satisfy all of these criteria, then citizens can know what the law is. They can govern themselves in accordance with the law. There's a kind of profound respect for the moral agency of citizens that is when they are governed by the rule of law, and not simply by arbitrary command. Yeah? So in addition to being able to function and work with your lives, right, under the sort of stable framework provided by law, and be able to conduct yourself in the light of state power, you're also able, by the way, when you have especially public rules that are public, right, you're also able to contest those laws, right? So if you know what the laws are, right, and you disagree with them, then you can challenge, you can debate about the content of the rule of law. Yeah? And in areas of uncertainty, right, you are able to, state officials offer interpretations of those rules, of those laws, right, that you can, in the appropriate forum, contest, right? As everyone in the room knows, right, laws are often unclear. So much of what you're reading in your cases, right, are interpretations of what the law is. And these elements of the rule of law, specifically this requirement of publicity, right, holds the state accountable. In general, right, so if you disagree with what the law is, in general, you can contest what the law is and what the law should be. And under conditions of uncertainty, you can have a debate about what the law requires. Yeah? All of these things, I suggest, reflect a profound commitment to the moral agency of citizens subject to law. Now, I want to highlight another kind of element of the rule of law, which is often understood to be essential to the rule of law. Right? So in addition to these 8 criteria, these 8 indicia, desiderata of the rule of law, and its underlying commitment to the moral agency of citizens who are subject to law, there's a kind of understanding that political power, if it is to be exercised in a system of the rule of law, must find its source in law. Yeah? Political power must be governed in a way that finds its source in law, right? And not, again, merely on the whims of those who rule. Right? And now that's important because it means that you, all of us who are governed under a system of the rule of law, right, are not subject to the arbitrary whims, the arbitrary fancies of those who rule us, right? They must find their power within the law, and the law, with all of these characteristics of the desiderata of the rule of law, introduce a measure of stability into your lives. So you are not subject to arbitrary power imposed upon you from above. Okay. So this is the definition, the rule of law. Yeah? 8 elements that satisfy fundamental commitments to moral agency, a requirement that the exercise of political power be authorized by law, which safeguards us against domination by those who hold power. Okay, that's the rule of law. That's the definition we'll be working with, the conception of the rule of law that we'll be working with. Now, what's the connection between the rule of law and law itself? Yeah. I hinted at this when I talked about the idea of a catastrophic failure on any one of those 8 desiderata. Right? And what I want to suggest is that if you have that kind of catastrophic failure to satisfy those criteria, and if you undermine the moral purposes of law, such that citizens' moral agency is not respected, such that they are subject to domination and the arbitrary whims of rulers, then what you have is not a system of law, by definition. Okay? So the rule of law is connected to whether or not you have a legal system. The existence of the rule of law is a sort of condition for the existence of a system of laws. And in the absence of the rule of law, what you have is nothing that is worthy of the designation, is worthy of the name of law. Okay? So connection between the rule of law and law itself. What then is the connection to democracy? You know? So if we have this idea of citizens who are respected by the system of rules under which they govern, who are respected by their rulers in the ways that I have specified, then I think we have a particular conception of democracy. Now, Pooja mentioned that I'm working on a program of deliberative governance, and we have a book coming out on deliberative constitutionalism. And the basic idea of this theory of constitutional law and of democracy is that democracy that is respectful of these kinds of values, these are values of the respect for the moral agency of citizens and for their capacity to govern themselves and to be free from arbitrary interference with the states, right, has certain features, right? And one of the features of a democracy in this kind of a system of the rule of, governed by the rule of law is that politics and the institutions of governance are not simply mechanisms by which people express and aggregate preferences, right? That is, if the idea is that those who are governed and those who participate in democratic life under the rule of law are engaged, as I said earlier, in a kind of exchange of reasons, right? About whether it's about interpretation of law or about contesting the substance of laws, there is a kind of, it's getting dark. Okay, it's getting dark, right? Did I just say something wrong? Is someone shutting me down?
Happens all.
Oh, does it? Okay.
Don't worry about it.
All right. Okay, so it's a particular view of democracy. This idea that the system of governance respects these moral capacities and these elements of citizenship argues against, my colleagues and I suggest, and not just my colleagues and I, but theorists of deliberative democracy since forever, argues against a particular version of democracy, a merely aggregative version of democracy, right? So in this idea of democracy, state action is not legitimate simply because it reflects the preferences of a majority of the people. Yeah? State action has to be justified, and has to be justified in reasons that are acceptable to those who are governed. Yeah? part because of the very structure of the rule of law, right? And so it is not enough to say that a majority of those people who agree with me because they prefer a certain outcome, right? And therefore, the state action that results is legitimate and defensible as a kind of normative theory of democracy. It's not, right? In order to be defensible as a theory of democracy, it has to have these qualities of respect for the agency of citizens. Okay, so there is, I suggest, a kind of fit between this deliberative conception of democracy and the rule of law. Right? They serve the same kind of ends. Right? So in a deliberative democracy, as opposed to a merely aggregative democracy, right? Citizens are engaged in the exchange of reasons, right? And they are subject to the authority of the state when they are given reasons for state action that they can reasonably assent to. Okay? So is this much clearer so far? Yeah, we have a conception of the rule of law that we say is intimately connected with whether or not that is intimately connected to the very definition of law, right? Things that do not comply with the rule, a system of rules that does not comply with the rule of law is not worthy of being called a system of laws. And the theory of democracy that underlies all of this is a deliberative, not an aggregative theory of democracy, right? The theory of democracy, we suggest, that is consistent with this version of the rule of law, places emphasis on the exchange of reasons and on reasons for governance that are acceptable to those who are subject to the power of the state. And that, we suggest, is different from a conception of democracy which is merely aggregative, which is merely about the will and desires of those of the majority of the people. Okay? So that is, the rule of law and democracy, what's the connection? That's the connection. Okay. So there's a connection between the underlying, another way to put it is to say that there's a connection between the underlying moral vision of citizens under the rule of law and under a theory of deliberative democracy. They serve the same ends. Okay? Okay. I see a couple of furrowed brows, but perhaps I will unfurrow the brows during the question period. So those are the definition. Those are the definitional questions. And that's the connection. So let me close I said I would go for about half an hour. So let me close by going back to our two statements that we started this session off with. Right? So remember, we said the very first statement that we had from Mr. Orange was that the leader enjoys the support of the majority of the people. Right? All actions that he undertakes that are lawful because he has received the support of the will of the majority of the people, right? And it will not be questioned. So the problem, I think we can sort of obviously see the problems of Mr. Orange's position, right? In light of our discussion about the connection between the rule of law and democracy. So first of all, let's start with the "and will not be questioned" part, right? We said that with the objective, one of the moral objectives of the rule of law, is to allow for accountability and contestability. Yeah? Laws that satisfy the criteria of the rule of law allow citizens to contest and debate and challenge the policies and the rules of those who rule them. So Mr. Orange, in his final piece, when he says that "and they shall not be questioned," right, is directly challenging an essential element of the rule of law, this idea of accountability and contestability. He also has an erroneous view of democracy. Yeah? That is, he said that by mere virtue of the fact that he enjoys the support of the will of the majority, his actions are lawful. But as we said, in order for the connection between the rule of law and democracy requires a conception of democracy that is not simply dependent upon the will of the people, right? But is rather informed by this respect for the reasoning agency of citizens and the importance of exchange of reasons. And if Mr. Orange were to govern consistently in this way over time, right, that is, in ways that are assume that simple assertions of power, right, discrete assertions of power, not through a system of rules that are worthy of the appellation of law, we would say that there was a catastrophic failure of respect for the rule of law. And in so doing, we would say that what he was engaged in was not lawful activity by definition. What he was doing is not law. So that's our response to Mr. Orange. Let's now talk about Mr. Turquoise. So Mr. Turquoise said that law is a morally neutral device. Yeah? There is no necessary connection between the rule of law and democracy, because the rule of law, the 8 desiderata, can serve all kinds of moral ends. Right? Now, let me offer the best version of that argument, the strongest and most influential version of that argument, which comes from Joseph Raz. Right? And Joseph Raz says that it is possible for a state to pursue all kinds of evil while respecting all of the 8 desiderata, all of the 8 criteria of the rule of law. Right? So if you have a system of slavery that is imposed, that satisfies all of these elements of the rule of law, right, then you have a morally evil system of governance, but it is nonetheless a system of law. And this shows that the law and the rule of law are morally neutral devices. Yeah? Because full compliance with the rule of law is compatible with great moral evil. The rule of law and law itself are morally neutral. That's the argument. Now I suggest that this rests on a kind of, and not just I, others, including Professor Simmons from Cambridge University, is that this suggests a kind of error. Yeah? And to sort of highlight the error, I think we can think about the goods that we saw served by the rule of law. Right? So the rule of law, even in a system of governance that imposes slavery, right? Even if it satisfies these minimum conditions of the rule of law, these 8 criteria, and it does so in a thoroughgoing and systematic way, right? Respects the moral agency of citizens in at least the ways in which we suggested the rule of law does, right? It addresses itself to citizens. Citizens can conduct themselves in light of the rules that they are subject to. They are not subject to the arbitrary will of the rulers, at least in respect of those rules, right? So, and so therefore, right, there are moral ends that are served by the rule of law, right? Those are not negated by the pursuit of substantively evil ends. Yeah? So I think it is a non sequitur to say that just because the rule of law is compatible with great evil, that it is therefore a morally neutral device. I suggest that even if you are searching, trying to achieve morally evil ends, if you comply with the rule of law, the virtues and the moral goods that come with governance by a system of law are still there, right? Even if at the same time you are pursuing evil ends. So the rule of law is not morally neutral, right? The rule of law still must serve its underlying purposes, even if evil ends result. That's a sort of a thin version of a response to this criticism. And so that is the connection between the rule of law and democracy, and a specific version of deliberative democracy. Right? And so I say that it is, in response to Mr. Turquoise, it is not what we were talking about when we talk about the rule of law, is not a morally neutral device, right? Laws are not morally neutral. They serve, if they have complied with the rule of law, they serve moral ends, even if evil can result. Now I said that I would conclude by responding to what I thought were some of the valuable elements of the critique about imperialism. Right? So remember, Mr. Turquoise didn't merely say that law is morally neutral. He also said that to suggest otherwise is to engage in a kind of cultural imperialism. Yeah? Now, I think that the best part of that criticism suggests something that I think is true, and that brings us into the territory of thick versions of the rule of law, substantive theory versions of the rule of law. Now, remember we said that the rule of law serves the moral agency of citizens, right? They're able to conduct themselves in light of the rules. They're not subject to the arbitrary will of the rulers. They can contest and reason about law, right? Now, you might say that in order to do these things, right, requires more than just a simple system of laws, right? It requires that your basic needs be met, right? If you are starving, it is hard to contest the actions of rulers, right? If you are illiterate, it is hard to engage in ways that allow you to interpret law. If you are in a system in which there is no freedom of the press, in which there are not free elections, it's hard to engage in the exercises of accountability and contestation that I said were essential to the rule of law. So I think the best version of the most serious interpretation of this charge of imperialism is to say that the underlying motive of the criticism is to say that the rule of law can take a whole bunch of different configurations, right? A system that complied with the rule of law may need to provide and protect different kinds of rights in different ways in different contexts. Nonetheless, I do want to say that there is a kind of moral core to the rule of law. And if the criticism of imperialism attacks that moral core, then we are no longer really talking about the rule of law. Right? So if you say that that moral core is not necessary, then we are no longer really talking about the rule of law. I'll conclude on that point, on that sort of definitional point. As I said at the very outset, these kinds of debates have been happening since forever in faculty seminars and in the courses that you take and teach. But there is a kind of urgency to the debates now in the world. And I think that, and Pooja and I, before we came here, we're talking about the different ways in which people do legal scholarship. And I think that legal theory, in particular in today's world, can have something to add to really important public debates about how governments conduct themselves. And that may influence how governments act and ultimately in how citizens are treated. So this is not merely a kind of exercise in university chit-chat. There might actually be some consequences in how we think about these very fundamental values, about these very fundamental concepts of the rule of law, and democracy.
Thank you very much, Hoi. I didn't want to preempt you or talk too much, but I'm really glad that you ended on the note that you did, because I think one of the things that we understand definitely in Hong Kong and also globally, of course, is how a lot of these conversations, which we start out talking about in our first year legal systems classes, in terms of the organization of the legal system, are now becoming very, very real, because we are seeing how these systems sort of operate in action, and the fundamental gap there is between a theoretical principle and how it might play out in practice. And I think revisiting sort of these principles is very, very timely. And certainly a lot of examples came to mind as you went down the checklist of 8. And I think particularly when you talk about Mr. Orange and Mr. Turquoise, I was given to understand that one of them would be a Ms., but it's okay. But definitely I think there's a lot of room there to start exploring and thinking about what these ideas mean in the different contexts in which we see democratic principles playing out, and particularly for Hong Kong, because we're on this, what seems like to be a perpetual or perennial quest for democracy. What kind of democracy are we after, and what are the values, mechanisms, but also the capacity for citizenship that we need to build in order to fully realize democracy in a meaningful sense. And I think that's where your talk sort of has left us at. We have plenty of time for question and answer, so please do state your name, affiliation if possible, and ask your question.
Thank you for the presentation. Actually, I totally agree with the interconnection between the two concepts or principles. But I just want to know how you see the relationship in a deeper sense. Now, Francis Fukuyama wrote about the transitions of the rule of law. That is, he found that there's a lot of people have written on the transition to democracy, but not that much on the transition to the rule of law. And he talked about the importance of looking at the sequence. So the two concepts, the rule of law and democracy, now they are interconnected, but in the real world, that they will not come at the same time, and they may come in a certain sequence. So to you, that what might be the sequence of the two? And that's a big implication to the real world, because in different parts of the world, maybe also in this part of the world, maybe we have regimes that are kind of more inclined to talk about the rule of law than democracy. I'm talking about mainland China, even though that rule of law idea may not be able to set aside that Hague requirements of fuller, but at least they use the language of the rule of law. And so how do you see the sequence? Would that be a must, that the sequence must be one follow the other, or the other follow the what? And so how do you see the method? Yes.
That's really a fantastic, great question. It's a delicate question. Yeah. So let me start by almost, it's kind of a semantic point, right? That is, if you are a government and you are not in any meaningful way complying with the underlying purposes of the rule of law, then I think it's probably a good thing not to say that you're complying with the rule of law, right? And this is, I think, important because then you can have a real debate about what you are doing. Yeah? So if you are engaged in a system, you have a system of rules, and they do not comply with the rule of law, right? And they do not serve the underlying moral purposes of the rule of law, that they do not respect the moral agency, that they do subject people to domination and to arbitrary rule, then I think it's helpful to say that this is not a rule of law regime, right? But there are certain services, there are certain purposes that are served, right? So governments need to provide order. Yeah? Governments need to provide services, right? And if you are not complying with the rule of law because you are concerned about these other things, then stop saying that you're a rule of law regime and say that we are turquoise. Right? We are something else. We are engaged in a system of governance that does not prioritize these things. Right? We're not respecting the rule of law, but we are doing these other things, and these other things are good things. Yeah. So that's, I think, just a first thing to say, and that's just a kind of semantic what governments should say about themselves. And I think it's unconvincing when a government says that it is complying with the rule of law, and it is manifestly not. Then what's the point in saying that you're complying with the rule of law? Yeah? Okay, so that's kind of semantic point. On the more general point about sequence, I guess the question is, when is it necessary? When do you have democracy in this sort of full sense, this deliberative sense that I suggested, right? And I think that I don't think there's a clear, clean sequence. I think these two things work together, right? That is, I think what happens is that you have a system of laws that institutes protections for citizens that allow them to trust and engage with the state in ways that affirm their agency and respect their capacity as reasoning agents. And that sense of agency, I don't think, can come about unless there is actually some kind of responsiveness, unless there is some kind of accountability, right? And in which there is some sort of exercise of mutual interpretation where laws are uncertain. Yeah? Fuller talks about law not being a one-way projection of power and authority. So I think that in a way, the rule of law for a system of rules and a system of government to be fully formed as a system of complying with the rule of law has to happen in tandem with the wider confidence within broader society that is in fact the relationship between citizens and the state. You know? And I'll just close on a final point. I don't think that it is only the state, right? It is not only the state which can contribute to a culture of the rule of law and a culture of democracy. I think that universities, I think that all kinds of civil society institutions can inculcate in people and can have an effect on the culture of society such that citizens expect that they are to be governed with this kind of respect for their fundamental moral agency.
Yeah,
Hi. Okay, thanks for the for your presentation. I had one.
Sorry, what? Dan?
Sorry, my name's Dan Matthews.
Sorry.
Dan Matthews.
Oh, Dan Matthews.
From the faculty
Oh,
here
great.
at Hong Kong U. And it was refreshing to be reminded of Fuller and his 8 lists and so forth. It takes me back to only last semester. These very things.
All the way back to last semester.
Exactly. Yeah. So my question is about one of the points that you made sort of in passing, which is about the nature of political power. You said, I think, political power must find its source in law.
Yeah.
It seems to me that the point that you're making with respect to the connection between the rule of law and democracy is that both have are connected by the respect that they show for the reasoning agency of citizens.
Yes.
But that's not found in law. That's not a legal. You don't. That's not a. There's no law that guarantees that. So is there not a tension or a contradiction in that point that the ultimate justification of the rule of law and your understanding of democracy goes back to a particular conception of reason, the nature of citizenship or the nature of the subject, and that's the ultimate basis for political power. Political power has to respect the reasoning capacity of agents. That's not anything legal.
Okay, great. So I think that the relationship between the moral agency of citizens and law is that for a system of rules to be legitimate as a system of laws, right, that system has to respect the moral agency. So it doesn't find its source, but it is reflected in the system of laws. Yeah? Now, when I said that the rule of law requires that political power be exercised in accordance with law, right? What I meant to say basically was that you cannot have political power exercised in a way that is undisciplined by law. I think is sort of the point, right? That is, political power is constrained and structured within the system of law. So imagine that you had a political leader that acted in ways that were completely outside the scope of her authority, and exercised political power, and it brought to bear on the citizen the power of the state, right? But that action did not find its source in law. Okay? You're right to say that the respect for moral agency doesn't arise from law, but the fact of this exercise of power it arises from sort of a personal exercise of power, right? That nonetheless uses the machinery of the state is profoundly disrespectful of the citizen, right? As a citizen that is subject to the rule of law. So if I gave the impression that the values of the rule of law need to find authorization in the state, that's not what I meant to say. What I did mean to say was the idea that political power must be exercised within a system of law is to sort of reinforce this point about power exercised in this way being respectful of moral agency of citizens, and political power that is exercised according to personal whim is not. Yeah.
Other questions? Well, Albert, yes?
Yeah, I'm Albert Chen. So, I think you're arguing that both the rule of law and democracy depends on this conception of respect for the moral agency of citizens.
Yeah.
But I suppose even this respect for moral agency of persons can be can have different content in the context of rule of law on the one hand, and the context of democracy on the other hand. In other words, they may not be exactly the same thing. Even though we call it respect for moral agency of persons, it may not be the same thing in the two contexts. Because in the context of rule of law, the respect is only respecting them as individuals who can make their own decisions about what to do after knowing what the rules are, so that if they choose to do X, they know that they may be punished. If they choose to do Y, they know that there are some other legal consequences. So, so people respect it in the sense that they are allowed to choose what to do after knowing what the rules are, and the ruler or the government will act or will respond to what citizens do, what people do in accordance with those rules. But the respect for moral agency in the case of democracy, particularly deliberative democracy, as you have advocated, is that we respect people's views about, say, matters of law and social policy, and we respect the reasoning capacity, so that we should, in a democratic system, have some way of promoting deliberation, so that people can exchange the reasons, as you said, and be persuaded to change their mind if they are convinced by better reasons. So my own view is that maybe there are two slightly different versions of respect for moral agency.
That's great. It was funny, as I was hitting that point in the lecture, I began to think, does this actually work? Every once in a while this happens to me. I think it does. So let me suggest that you're right to say that there are differences in the moral agency that is respected under the rule of law and democracy. And so in particular, and this is the position that many people who argue the fuller line of the debate about the rule of law say, right? That is, I said earlier about the thing about the one-way projection of authority, right? The idea is that citizens are respected in their capacity to follow the law and to interpret the law, right? And so that is one of the virtues of the rule of law. I want to say something more than that, though. Yeah? I want to say that in the capacity of citizens, one of the reasons why the 8 desiderata are important, and especially, for instance, the one about publicity, right, is that it allows for contestation of what the ruler says. Yeah? And so I think that in addition to simply being valuable because they allow people to conduct themselves in relation to the law, the rule of law also sets out the conditions under which people can contest the laws, right? And that, I think, moves us into the universe of deliberative democracy and of a theory of democracy, right? That is, under my interpretation, the rule of law is not valuable simply because it provides stable guidance, but because it also opens itself up to contestation and revision. And if it does that, then I think we are in a theory of democracy, and we're in the realm of democracy, not simply of the rule of law understood in terms of the ability of citizens to conduct their own affairs under the umbrella of law. So I think that that's the connection between the two. So there is a sense in which the moral agency is distinct, but both serve this ability of citizens to hold power to account. Yeah. And then also, just finally, on legal interpretation, as you know, laws are often unclear. Yeah? And so when people engage in interpretations of the law, they're owed a kind of set of reasons that they could reasonably assent to. Yeah? So if you think about the domains of administrative law, right? And so many people say that administrative law is probably the best place in which deliberative democracy fits in a modern state, right? And so the requirements under administrative law that actions of administrative agencies or tribunals be reasonable. Yeah? That has resonances with the rule of law, because it is state action, to go back to Dan's point, it is state action that is undertaken under the authority of law, right? But it also has kind of deliberative democratic elements of it, right? That is, you are owed reasons that you can assent to within the structure of the legislation that empowers the tribunal. And then finally, as you know, in constitutional law, the reasons that are given under a constitution have to have this kind of resonance with the requirements of public reason. Right? So you're absolutely right to say that there are points in which moral agency is distinct, but I think there's sufficient overlap that the two pieces of the rule of law and democracy are intimately connected.
I have a couple of questions.
Great. Sorry, who are you?
Oh,
I have a question too. Who are you?
I'm Larry LeBon, president of LA Enterprises.
Okay.
Number one, Trump. Here's a guy who runs companies. He becomes president. He thinks, I'll just do executive orders
Yeah.
and run the whole shebang like that.
Mm-hmm.
I mean, this was unrealistic on his part.
Mm-hmm.
Okay, number two, Hong Kong has rule of law, but it doesn't have democracy. So does Singapore. India has democracy. But what works better? Singapore, Hong Kong, or India? That's all I want to say.
Okay. No, that's great. Thank you so much. Okay, on executive orders. So, absolutely right. That is, if you try to govern a complex, pluralistic society simply through fiat, and I'm not saying executive orders are just fiats, but let's just say that I think that's the sort of the implication of your point. Then yes, then you have a kind of disregard for the rule of law, and that's a problem as a matter of practice because it's hard to run a complex, massive society through a discrete set of orders. But it's also a problem because it doesn't apply to the rule of law. Remember, we said that the first element of the rule of law is that there's governance by rules. On the comparisons between Hong Kong, Singapore, and India, there is, as you say, an element of governance by rules which raises issues of efficacy, right? That is, to go back to the criticism of the rule of law, my version of the rule of law that I suggested at the outset. Remember we said that one criticism of the rule of law, my version of the rule of law, is that it misunderstands the idea of the rule of law. Right? So Mr. Turquoise says, the rule of law is simply a technique, simply a neutral mechanism by which you achieve certain ends. Now, one of the ways in which governance by laws achieves certain ends is that it allows for the efficient achievement of ends. Right? That is, there are good reasons to govern through a system of rules other than moral respect for the agency of citizens, respect for the moral agency of citizens, right? So you can have a very effective, efficient system of governance through laws, right? And so I think that's sort of your point. That is, which is more effectively governed? Well, if you govern yourself through a system of rules, then yes, there are going to be gains in efficiency. You know? And then on your final point about whether or not certain systems are democratic, despite the fact that they have the rule of law, that's sort of the point of the talk, right? The question is whether or not a system can call itself compliant with the rule of law if it does not have a kind of respect for moral agency that comes through something like deliberative democracy. Now, the mechanisms by which governments are held to account may vary across contexts, but I think if there is no accountability of the governed to the governed, then it is hard to say that there is a foundational respect for the moral agency of citizens. And to go back to the point from Albert, whether or not there is a meaningful capacity for citizens to hold those who rule over them to account.
One last point.
Yep.
In the United States, it could be arguably said that lobbyists have a tremendous power over what happens, and they're not elected. So can you really say the United States is a true democracy?
I'm not going to answer that question, but I'll answer the question about lobbyists, because that fits better into my argument. Yeah. So I would say that what you're pointing to is the influence of lobbyists and the influence of interest groups. Let's say you have a government that is completely determined, their policy is completely determined by interest groups and lobbyists, right? We'll call this the United States of Turquoise. Yeah? UST. In such a system of government, the determining factor of policy, right, is the simple will and the preferences of the majorities, right? The simple preferences of those who have access to power, right? And I would say that that is not a legitimate democracy under the terms that I've set out here, right? Because there is no, and I think this is your intuition, your idea, there is no real respect for citizens there, right? In that kind of a world, all that matters is the capacity of people to aggregate their own political power and preferences to affect to affect policy, and that I suggest is not in any sort of deep and meaningful way respectful of the agency of citizens, and therefore is not a legitimate, I would say, form of democracy, because it does not have that at its heart that concern for the agency of citizens that deliberative democracy argues for. Thanks for your questions.
Okay, thank you.
Hey, Sonny.
Just interested in your point that you made in relation to Albert's question about how rule of law involves this element of holding the power to account.
Yeah.
I'm just very doubtful that's part of the thin version of rule of law. And I would have thought that what might be more tenable is the idea that you have to, the rule of law sometimes requires a neutral arbiter because there are disputes over the law, and you need the neutral arbiter to give an authoritative statement of the law. And I think that's somewhat different from holding the executive power to account. And you use the example of administrative law, but in some public law or administrative law contexts, you also find examples where government themselves will go to the courts in order to clarify what the law is. In Canada, you have the reference mechanism. And in that way, the courts are serving a role of clarifying the law in order to help contribute to the resolution of possible disputes or possible disputes. And I wonder if that's a more tenable concept of thin version of rule of law.
No, that's great. Thank you so much. So I guess a starting point might be to say, look, I started with the thin version. I'm not sure where I ended up. Yeah, that is, I think that the substantive values that I import, someone might say, look, you're just arguing for a thick version of the rule of law. And so I don't want to say that what I'm arguing for is exclusively a thin version, but I think it can be derived from the thin version. So I think the thinnest of the thin version is Joseph Raz's version of the rule of law, in which he says, look, there is no moral content here. This is it's just a sort of morally neutral instrument, law and the rule of law. So I start with the thin version, but I think I go somewhat farther than the thin version. And the step I take is, I think, sort of what I understand to be kind of a corollary of this idea of respect for moral agency. That is, respect for moral agency is not achieved simply by virtue of being told clearly what the rules are and being able to guide your conduct in light of those rules, but in being able to, particularly in conditions of uncertainty, being able to contest an interpretation, right, of what the rule of law is. So to take your point about the rule of the judiciary and the rule of a neutral third party, I think that you're right that that is fully consistent with a thin version of the rule of law, but I think it's also consistent with my more robust, we'll call it thin-ish version of the rule of law. It's a
Thin plus one.
Thin plus one. It's so in Montreal, real estate agents often advertise properties as being desirable by saying adjacent. Like, so you're adjacent to a really nice neighborhood. So it'd be like mid-levels adjacent. My rule of law theory is like thin adjacent. But so I think it's consistent to say that a neutral arbiter is important for a thin version of rule of law. I think it's also important for my Finnish version of the rule of law because that's a forum for contestation. And finally, just to round out the thought, I think the requirement of publicity serves two kind of ends. Right? That is, on one hand, it allows for people to guide their conduct, but it also makes the state action public and justifiable, right? Subject to justification. And if it is subject to justification, then I think it's not that far to say that it is also opening those who rule to accountability.
Okay, I think we've reached our time. Thank you so much, everyone, for your participation in the conversation, and thank you so much, Hoi, again, for elaborating your ideas. And I'm sure that it's given us all a great deal of food for thought. So we'll be probably getting in touch with you with questions as they spring up. Please join me in thanking Hoi so much.